Good afternoon, students. Today, under the topic of international law, we will be discussing the sources of international law. So in the last class we have understood what the international law is, how it is different from the domestic law or the laws which are followed by the respective nations. So international law, if you see, international law means basically the law that is been followed all over the world, that has a general acceptance, that is followed all over the world between states, between different countries. So suppose United Nations, Charter of United Nations, UNO. The Charter of United Nations, since United Nations have 193 members, the last member was South Sudan. So United Nations Charter, since 193 countries are the members of the United Nations, they follow the rules, principles, regulation laid down in the United Nations Charter, and since it is followed by almost all the countries all over the world, it could be called as an international law. So international law, always remember friends, is any law that is been followed in more than one country. So it has to have some extraterritorial operation in order to consider it under the under the concept of international law. So if you have to make any, or if we have to consider any law as an international law, it must have some extraterritorial operations. So that is why it is called international law. That means law between two nations. Law between two nations. Law between two nations or two or more nations could be called as an international law. So in the last class we have also discussed about various definitions given by jurists like Bentham, who is called as the father of modern international law, by Austin, by Oppenheim, lot of other jurists. So through that discussion we have an idea about what the international law is all about and what is the opinion of the jurist about the concept of international law. So different jurists, some jurists say that it is a weak law, some jurists say that it is a proper law. That we have discussed in detail in the last class. So today let us discuss about the sources of international law, how the international law came into being. So today we know that there is several international organizations like WTO, UNICEF, WIPO. There are a lot of international organizations are there. There are a lot of international communities are there. G7 committees, G7 countries are there. G20 countries are there. Lot of organizations, lot of international bodies have presence all over the world. Now that before all that, how the concept of international law came into being, how it ultimately boils down into a law that could be followed in more than one country, how the concept of international law came into being, how it was established. So in order to understand that, we have to go back and see what are its sources, how through the evolution, historical evolution, it has been shaped as a law which is followed in more than one countries and have attained the respect of several countries and have attained the nature of international law. So one of the most primary sources, we could say, since international law sources, what we will be discussing under international law is that there are various sources, but whatever the sources I will be telling you, it's not exhaustive. There could be other sources also, but in this class we will be primarily discussing about 4 sources. So the first source that we will have to discuss is custom. So before that, one more thing that we have to discuss about is about Article 38 of the Charter of International Court of Justice. Article 38 of the International Court of Justice, if you see Article 38 of the International Court of Justice, it talks about that the International Court of Justice, while delivering a judgment in case of any dispute between two countries, would primarily rely on 4 different aspects or 4 different sources to deliver a judgment. So what are the 4 different sources which the International Court of Justice will take into account while delivering or while pronouncing judgment? So first source is international customs. Second source is international conventions. International customs. International conventions. General principles of law. And treaties. And fourth is judicial precedents. Judicial precedents and opinion of jurists. So as I have already told you, these are the main 4 sources of international law. This list is not exhaustive. You cannot say that this is the only source of international law. Other sources of international law could also be considered, but this is the primary sources of international law. So International Court of Justice, while delivering any judgment, will take into account first of all custom, then conventions, then general principle of law, and then judicial precedents. So one by one we will discuss all of them in order to have a better understanding about how international law came into being. So one of the most original sources of international law, is international customs. Now what is international custom? Custom, if you see in general sense, means anything that have been followed, anything that have been recognized by the community, by the society for a very long period of time. Like in India, in the international customs, if you see, there are a lot of rituals, there are a lot of practices followed by different followers of different religion, like Eid, Deepavali, Holi, you can see Chhat Puja. They are all what? They are all customs which have been followed for thousands of years, and they have been continuously being followed. So custom means any practice which is continuously being followed without any break for a very long period of time. Now, international customs are those customs which are, or usage or any practice which is being followed by more than one country for a very long period of time. For such a duration that now it has been accepted as a practice which is binding on all the members who have been practicing it. So one thing we have to understand is, in case of international custom, we have to differentiate between what is usage and what is custom. There is an essential difference between an usage and custom. Usage is also a practice which is being followed for a very long period of time between 2 or more countries, but it does not have a binding nature. That means if a country does not follow it, it will not be punished or it will not face any sanctions. But here in custom, it has attained binding nature. That means if a country does not follow that custom, then it will have to face certain consequences or repercussions, like diplomatic, the case of diplomatic asylum, human rights, issues, the issues of refugees, these are all one of the examples, some of the examples that we can take, like in case of asylum. If a person has fled from one country due to persecution or due to any political reasons, like Dalai Lama has fled from Tibet because of fear from China, and he is currently given asylum by the Indian government. So it is a general custom that if any person due to persecution or military or political reasons have fled from some other country to some other country, then generally on humanitarian ground or political ground, other country, it is an international custom for that country to give asylum or to give protection to that particular person. So it is generally being followed by countries all over the world. Now it has attained the nature of an international custom. Similarly, human rights issues, in case of genocide, in case of mass persecution of a particular religious community or minority group, if there is any, then such issues are also taken very serious by the countries all over the world, and generally countries take sanction against that country which has persecuted minority group or religious group. Like in case of refugees, a refugee, if a particular person has taken a refuge in a particular country due to any reasons, then also the other country cannot refuse such persons on humanitarian grounds. Like diplomatic immunities, like if a person as an ambassador of a country or minister of a country has visited some other country, it is generally not tried or generally not persecuted or prosecuted in some other country for any crime. Suppose in case of India, you have seen lot of cars in Delhi and NCR area which have blue number plate. So blue number plate cars generally are excluded from the purview of traffic rules. So if a blue number plate or embassy car has violated any traffic rules, then there will not be any challan of that car because it has certain diplomatic immunity. So certain ambassadors, certain councillors, certain ministers of the nation, when they visit some other country, they have certain diplomatic immunity. It is also a kind of a custom which is followed for a very long period of time all over the country. So customs, always remember friends, is something or some practice which is being followed by countries all over the country for a very long period of time. Such a long period of time that it has attained the nature of a binding. It has become a binding principle, and any country which does not follow such custom will face certain repercussions or sanctions by other countries. Usage is also a practice, but it is not of a binding nature. So it could be said that in international law, custom is a very important source of international law, because when a custom is being followed for a very long period of time, it formulate or it crystallizes into some kind of a treaty or convention or charter, like UN Charter, United Nations Charter. United Nations Charter is nothing but customs, group of customs which has been codified in the form of a UN Charter. So customs is one of the original sources of international law, any practice which has been followed for a very long period of time. Now when it is codified, it becomes treaty, conventions or charter. Now let us discuss about some of the principles. Let us discuss about some of the principles of international custom. How you can say that a particular practice has become a custom. How you can identify such practice as a custom. So when we talk about custom, we have to also discuss about its nature. How to identify such practice as a custom. So under the nature, you can say that there are 3 points on the basis of which you could understand or you could identify a particular practice as a custom. First is duration. Second is uniformity. And third one is generality. Duration, uniformity and generality. Duration means it has been followed for a certain period of time. It has been followed for a certain period of time by many countries. That's why it has been generally accepted as a custom. Now what is the duration? Should it be 5 years? Should it be 10 years? Should it be 20 years? It is not specified. But it has to be followed consistently for a certain period of time. Like in case of a duration, if you see, a usage may become custom even in a short time. So duration is a essential criteria, but long duration is not. Like, all depends upon the circumstances of the case. Like in case of a continental shelf, after the Second World War, the principle of continental shelf was introduced in 1945. From 1945 to 1958, it was accepted as a custom. Now only within a period of 13 years, it has been accepted as an international custom. There are certain other practices like giving diplomatic asylum. The practice of giving diplomatic asylum, even though it has been followed for a very long period of time, it has not attained the character or it has not attained the shape of a international custom, because many countries follow it, many countries also do not follow it or recognize it. So duration is an essential aspect, but long duration is not. Second point is uniformity or consistency. Second point is uniformity or consistency. Uniformity or consistency means it has to be followed continuously, consistently. There should not be any break. If there is a break in the practice of that particular custom, it will remain usage or practice. It will not attain the nature of a custom. So consistency is a very important aspect of a custom. Generality means generally followed by countries all over the world. So suppose 1 or 2 or 3 countries follow a particular custom, it will not be accepted by international community as an international custom. So in order for a principle or rule to be considered as a custom, it has to be followed by many countries. So until unless many countries follow it, it will not be considered as a custom. So suppose if 1 or 2 or 3 countries follow it, it will not be considered as a custom. So many countries should follow it in order to consider it as a custom. So these are some of the nature or features of a custom by which you can identify a particular rule or principle as a custom. Now the second source of international law which we have to discuss is the treaties. So friends, do you know what the treaty is? Treaty is basically any agreement, arrangement made between two countries to solve certain issues, like North American Free Trade Agreement, NAFTA. It is between Mexico, Canada and United States. It is a trade agreement between these three countries, that whatever the export or import or any trade or commerce that is being done between these three countries will have certain privileges, will have certain exemptions in import, export duties and other relaxations. So it's a type of a agreement regarding trade and commerce between these three countries. So it's a kind of an arrangement or agreement. So treaties also, international treaties, when we talk about international treaties, it is also a kind of a arrangement or agreement. So always remember, treaties should be between more than two countries. Two or more than countries. Treaties means arrangement or agreement between two or more countries. Generally what happened is that treaty generally is nothing but a codified form of custom. Codified form of custom. So when a custom is being followed for a very long period of time, generally it is codified and it becomes treaties or conventions. Generally people confuse that, they think that treaty and convention is one and the same thing, but it is not. Conventions are generally those treaties or arrangement which is between many countries. So if many countries are involved in that treaty, it will become a convention. Treaties are generally between two or more countries. That's why it is called bilateral or tripartite treaties. That means two or more countries. If the treaty has many international countries involved, then it will become customs. So always remember friends, treaties are nothing but codified form of customs, and treaties is also a very important part of international law. So if International Court of Justice has to decide a particular case, it will take into consideration, primarily it will take into consideration the treaties between those two countries. The third source of international law is general principles of law. The third source is general principles of law followed in many countries. So if there is general principle of law which is being followed in many countries, then it could be considered as a source of international law in an international organization like ICJ, WTO, WIPO could take into consideration when deciding a particular case. Like for example, you can say that res judicata is a general principles of law. Principles of natural justice is general principles of law. Human rights is a general principles of law which is recognized by many countries. Like that, there are many principles which is followed by many countries all over the world. Many domestic courts or national courts of the countries follow such principles. Since it has been extensively or widely followed by many countries, it has attained the character of an international law because it has been followed in many countries. That's why whenever international organizations like ICJ deliver a judgment, they take into account general principles of law. Then on the basis of that, they give their judgment. So res judicata, natural justice, human rights, ex et bono, that is on the principles of natural justice, good conscience, common law principles, they give their judgment. Ex equate et bono is also one of the principles of followed by countries all over the world. Equate et bono means according to the principles of equity, good conscience and justness or fairness. So these are all the principles. This is not exhaustive list. There are many other principles which is followed by countries all over the world, and they will consider such principles as a part of international law. And the last part is Then the last part is judicial decisions. Judicial decisions. And the last part is judicial decisions. Judicial decisions are the decisions which are given by the domestic courts of the countries all over the world. Suppose in case of principles of natural justice, countries have given on the basis of principle of natural justice a particular case, they have decided in a particular manner. Now if a particular case has been decided by many countries all over the world in a particular manner, then since the judicial decisions of many countries is same on a particular issue, it could be considered as a precedent. It could be considered as a precedent, and it could be followed by international organization or respected by international organization as a source of international law. Similarly, there are various international organizations like ICJ, International Court of Justice, WTO, WIPO. They also give judgment. Whatever the judgment given by these international organizations, if when deciding a particular issue, it could also be taken into consideration when a particular international organization give any judgment on the basis of the facts which are similar to those which is given by this international organization. So it could be considered that the judgment given by domestic courts or given by international organization as a source of international law, because it guides us in deciding a particular issue or particular dispute between two or more countries. So it could be considered as a source of international law. So thank you so much for patiently listening, and I hope that you have understood the concept of how the international law is established through its various sources. Thank you so much.